First of all, I would like to greet the Macedonian Young Lawyers Association for the European Implementation Network, EIN. The lectures, George Stafford, the director of EIN, and Agnes Ciceron, Program Financial Manager of EIN. I want to greet their enthusiasm for organizing such an important training, which will provide adequate education for lawyers when we are facing global challenge which makes normal functioning difficult on every level. The topic which will be developed within the Weibner, making judgments lead to justice, enhancing the capacity of North Macedonian lawyers to advocate for the implementation of Strasbourg Court judgment. I appreciate it's especially important because the Republic of North Macedonia, with the ratification of the European Convention of Human Rights, has undertaken a number of obligations, including the obligation to enforce judgments of the European Court of Human Rights. The role of lawyers in the whole process is especially important, who, by the monitoring the process of enforcing the judgment, of their clients, primarily are following whether the established violence of the rights guaranteed by the convention have been properly removed. Also, the opportunity for the lawyers to use the various available mechanisms of the state does not take the necessary measures to enforce the judgment are leading to the strengthening the system of protection of human rights and consistent exercises of the principle of the rule of law. The role proper implementation of the decisions of the European Court of the Human Rights, arresting from the Article 46 of the Convention in the clearest evidence of the effectiveness of the convention in the protection of human rights and freedoms domestically, the process of legal definition of the execution of European Court of Human Rights judgments is regulated in 2008 with the law of enforcement in European Court of Human Rights discussion, whose implementation began in 2012. I would like to emphasize that the Committee of Ministers pays special attention to the effectiveness of the measures in terms of preventing future similar violence of the Convention and thus preventing the so-called cloned cases before the European Court of Human Rights with the allegations of the same of similar violations of the convention as those already established by the court in previous judgment. This is particularly important in terms of the extremely large number of applications from facing the European Court of Human Rights in recent years, and the need to ensure the long-term efficiency of the enforcement system. Actually, lawyers have an extremely important role to play in this process, and this is why I emphasize that the organization of this type of training is very important for the rule of the law in general. I want to thank you to all of you, because as I see the members of this course are young lawyers. This is especially important because for the lawyers, including me, that we were born earlier, I don't want to say that we are older, but earlier, this is important thing, but the future is for the young lawyers. So thank you very much for everybody, to everybody here that are present. I want to thank in the name of the Bar Association and all the members of the Bar Association of the country. Thank you very much.
Thank you so much for that, Lubomir. That's a fantastic introduction. But now I'll pass over to Zoran to continue the introduction. You'll need to unmute your microphone there, Zoran.
Okay. Thank you very much, George. Thanks for everyone to join us today. I would like also to catch up on what the President Mikhailovsky said. This important webinar for us because of the implementation of the verdicts of the European Court of Human Rights, because as the President said, there is no satisfaction if you can win a judgment without having the possibility to implement it and to change something on better. So that's why we are here today. I would also say a few words that our cooperation with the European Implementation Network is relatively young, but we see great potential. They have helped us understand the importance of the implementation of the ECTHR judgments, but also the mechanisms how to do this. So we are also looking forward to this introductory, I would say, meeting, and I will get back again with my part of the presentation. So I will just use this opportunity for everyone who are here to introduce you Agnes and George, because they are our guests today, or we are their guests today, never mind. George has joined EIN 2 years ago, I would say, something like 2 years ago. He has previously worked at the European Court of Human Rights, the Council of Europe, and the Georgian Young Lawyers Association in Tbilisi. And he originally qualified as a barrister in London, where he also worked as a judicial advisor in the Court of Appeal. So this is George. And Agnes joined the European Implementation Network in December 2017. Before joining EIN, Agnes worked for 15 years for the Assembly of the European Regions and took part as an expert in the work of the European Committee of Democratic Governance and the Council of Europe. In 2015, she coordinated a mission to the Council of Europe to implement a project aimed at strengthening local governance in Albania. Agnes holds a master's degree in international law, international relations, and foreign languages from the University of Bath and the Humboldt University in Berlin. So this is Agnes, and that will be for now from my side. And I give the floor back to George now.
Thank you so much, Zoran. That's really kind of you. What we'll do now is start the process of doing our presentation. And my colleague Agnes here will just pull up the PowerPoint presentation. So hopefully we can all follow along pretty straightforwardly. So you'll see from the agenda here, the rough scheme of what we want to talk to you about today. The timings will be slightly delayed, I think, to make sure that we can fit everything in. So please bear with us if things aren't exactly to the timings set there. So we'll start off with the welcoming remarks that we've already had, and then I will talk briefly about the implementation of Strasbourg Court judgments in general and why it's so important for you to pay attention to this very important issue. Before Zoran will talk a little bit about the situation in North Macedonia for implementation of ECHR judgments. My colleague Agnes and myself will then go to more depth about the process to help explain to you exactly why and how you can engage in the implementation monitoring process over a series of different slides and different explanations of that issue. After that, we'll conclude with a bit of a general discussion. We'll hope to get some views from you. If we have time, it'd be fantastic to hear from you what you need to know about, what we've left out, what we can tell you about. We'll also hopefully have some time during this period to see some interesting questions and answers from you and to get some engagement from you. But for right now, Agnes, let's start off with my presentation about the implementation system and why it's so important to engage with it. So let's head off to the next slide.
Yeah, that's the wrong one. So let's jump.
Okay,
yeah.
Jump a little bit there. Fantastic. If you go back one slide, Agnes.
Sorry.
That's okay. Okay, great. So the first thing I'd like to say, if we go to the next slide, thanks, Agnes. Perfect. Everyone knows about the European Court of Human Rights. Most lawyers will see it as a kind of bastion of justice, and they'll be familiar with the strength of its judgments and the importance of them to legal systems across Europe. But far fewer people know about the implementation phase, what happens next. So when a case is passed out of the European Court of Human Rights, it goes to the Committee of Ministers of the Council of Europe. The Committee of Ministers is meant to make sure that justice is done, not just for the individuals in the case, but for the whole of society. So individuals get a remedy, for example, by obtaining compensation or being released from jail. When it comes to wider society, reforms are meant to be carried out to ensure that the same problem does not come back again. So suppose a journalist is jailed on charges that are invented or fabricated. After winning a case at the European Court of Human Rights, not only would they need to be released, but the law and practice of the country would need to be changed so that the other journalists would not run into the same problem. So I mentioned that this process is not particularly well known. It's really important to say also that the problems of the process are not well known. So the first thing I'd like to say is that of the leading judgments handed down from the court in the last 10 years, about 43% are still pending implementation. So those judgments which identify a structural or significant problem in a country, all of those, 45% of those are pending implementation, and that's a really serious problem. So it's a problem, of course, but it's also an opportunity. And the opportunity is that whilst these judgments are pending, they can be used by civil society in order to obtain reforms in the country and make things happen. So whilst it's a problem that there's around 1,200 pending leading judgments of the European Court of Human Rights, it's also a great opportunity for civil society to use those judgments to achieve change in their own countries. And I want to talk to you, explain that a little bit with this example. So there was a domestic violence case in regard to Moldova in around 2014 was when the European Court of Human Rights handed down their judgments. And the judgment essentially said that there's a widespread problem of domestic violence in Moldova, but also that the authorities aren't taking action to stop it. So the authorities are not taking seriously the complaints of women who are being beaten up by their partners, and also that they're not looking into the complaints and prosecuting the people who are carrying out this abuse. So let's fast forward to 2019. The government then claims that the problem's resolved. It provides lots of data that they say there's much more prosecutions, things are happening. There's sort of evidence that they submit to the Council of Europe when they say, look, things are solved. Domestic violence in Moldova is well on its way to being addressed by the national authorities. What happens then is that NGO makes a submission. we're in contact with the Women's Law Centre in Moldova, which are a great women's rights NGO in that country. And they say, hang on, wait, there's still a big problem here. We haven't resolved this problem. They highlight various serious ongoing issues. So, for example, that women aren't being properly supported. They don't know about their rights. They don't know about the opportunity to raise their cases with the authorities. And when they do complain, they're not offered protection to prevent the violence that's happening. So although there were more prosecutions happening in Moldova, they didn't seem to prevent the assaults from happening in the first place, because prosecutions were resulting in very, very low sentences. And they weren't being followed up also by the kind of other services, protection services that were necessary to prevent the problem from affecting people in the first place. So after the NGO submission was made, the Council of Europe Committee of Ministers essentially said, yes, we agree with you, NGO, this is still a really big problem. And what happened then was the case was kept open, and a decision was issued by the Committee of Ministers, which included many of the recommendations made by the NGO. So the Committee of Ministers said, yes, you do need to provide more evidence, Moldova, about resolving some of the underlying problems that have been identified by the NGO. And also what happened then was domestic violence was included into the Council of Europe strategy for Moldova in the next 5-year program, and a project was initiated to address the problem. So that's a bit of an idea about why it's so important to engage with the implementation process and for NGOs. And there's 3 reasons I want to just highlight there before I come to a close. The first is that it's very important to set the agenda for reforms. As I said in that example, you saw how the Women's Rights NGO was able to identify measures to be taken by the government, which it had not taken yet, and also identify the evidence that showed such measures were necessary. So that's very important. The second is to push cases forward. I mentioned the fact that there's a lot of pending leading cases that are waiting to be implemented. And there's lots of different reasons why that's happening in different countries. But what can really help in all countries is civil society activity to highlight the fact that these cases aren't being implemented and to help push the implementation ahead. The third is to prevent early case closure. I mentioned in that example that the Committee of Ministers kept the case open after the submission from the NGO was made. And that's really important because the government was essentially saying, look, there's no more things to be done, let's have the case closed. And effective submissions from civil society, which contain strong evidence for maintaining cases open, can prevent that from happening and make sure that this ongoing reform process continues. But I think that's enough for me for now. That's the general picture, I would say. I think we've covered some of that material already, Agnes, in my spoken words. So let's go ahead to look at the overall picture for Macedonia, and I'll hand over to Zoran.
Okay, thank you very much, George, for giving this introduction. I will be very short, actually. When it comes to our country, we are in the, let's say, in the average of the countries of the Council of Europe for the implementation of the leading cases. So we have pending 36% of the cases. This is out of 54 leading cases over the time. So we have 45 leading cases, 8 leading and repetitive, and 1 leading and friendly settlement. So these numbers maybe don't look very high, but I would say that it is a very serious challenge because of the domains of the European Convention of Human Rights that are violated with these cases. So we are speaking about cases that are, most of them are protection of property. There are 4 leading pending judgments on this. Also access and efficient functioning of justice. There are 3 leading pending judgments. Also protection of private and family life. There are also 3 pending judgments in this area. Right to life and protection against torture. 2 leading pending judgments, very important one. freedom of assembly and association, one case, and also protection of the rights in detention. There is one pending judgment on this one. I would also like to say that the average time pending for leading judgments is 3 years and 10 months. I would say that there is a very big challenge in the Macedonian institutions, mainly the Bureau for implementation of the Strasbourg cases and for representation of our country with Strasbourg. Many years they have been, they did not have sufficient staff to work there. This inter-institutional group that is supposed to develop and look at the cases was used to not function at all. So I'm speaking that at the time that we were following, there were only 1 or 2 meetings every year. So this is very little one for having this big amount of cases. Very important that there is no action plan or action report in 36% of the leading cases, 5 out of 14. This is also something that is showing that we need to strengthen our capacities in this area of work. In the last few years, we had very good cooperation with the Bureau and with the government agent. They are willing to cooperate. That's very good for all of us. But I think that there is lot of, they need some kind of push. And this push should come also from the attorneys and from our side. Because as we checked all the data, there is only one case that has been challenged or that was for implementation. And the other one are simply waiting. Maybe it's not because of the attorneys are aware of this possibility that they can challenge the implementation in front of the court. And I think this is something that we also want to use maybe and speak about at the end of this of the official presentations. We have prepared a full list of cases that are leading cases and violations that they have been judged. So after the end of this webinar, we will also share with you the full list of cases. I will not go into the details of the case, but it's good to know about some very important cases that were very exposed in the media at one point, are still waiting or pending for implementation. This is something that we should be aware of as a legal professionals. And also the Rule 9 submissions. You know, this is something that to be honest, for me, I just found out a few years ago about these submissions. And as we found in the statistics, there were only 2 submissions made under Rule 9.2. And it was related with the Bekteshi community and others against North Macedonia. Maybe the colleagues will add something on this also. So I will stop here just for you to have this overview of what is happening in our country. And I'm of course open for discussion afterwards.
Great, thanks so much, Zoran.
Sorry, may I interrupt you?
Go ahead, Lumir.
Yeah, please. I want to ask you to excuse me because we have to write some documents to the government according to this crisis situation about the protocols in the court. So I want to excuse myself because I will log out, okay?
It's a pleasure. Thank you for joining us.
Sorry, during this seminar, maybe you will invite me again to speak, okay? So I hope that I will see you in live. I mean, sometimes you will.
Real life.
Zoran, we will meet each other for sure. But okay. Thank you very much for the invitation.
It's a pleasure. Thank you for being with us.
Thank you very much.
Okay. Thank you so much, Zoran, also for that information. I think that's some of the key statistics are put out there for North Macedonia. I think it's really worth highlighting, from my point of view, a couple of statistics there. There's the overall number of pending leading cases is 14 for North Macedonia. So those it's important to say that those cases are those that highlight significant structural or serious problems in the country. And each leading case forms a group of cases and can include repetitive cases. So repetitive cases are examples of the same problem. So for example, there might be a leading case, for example, on freedom of religion that was mentioned earlier by Zoran, where a church has been refused registration in the country. And if there's another case that comes out from the European Court of Human Rights, which is the same example of the problem, that will be a repetitive case. So there's many more cases pending implementation in regard to Macedonia than the 14 leading cases. But it's important to bear in mind the leading cases number, because those are the ones that represent the existence of an underlying problem. I hope that makes sense, and it's something we can come back to if it requires clarification. But for now, I'll pass back to my colleague Agnes, who's going to tell you a little bit more about what you need to know about the judgment execution process.
Yes, thank you very much, George. Actually, you already started to point out a very important element, namely the difference between the leading and repetitive cases. This is parts of these, let's say, key elements which I would like to go through with you today. Because as Zoran said, it's important to be aware about the cases, and it's also important to know that as lawyers or NGO representatives, you can also take part in the process. But let's go first through the key elements. I hope that the majority of you had the possibility to watch this video. I won't play it here. You have a link when you'll get the PowerPoint at the end of this presentation. That's a video actually in Macedonian, which explains within 5 minutes the supervision process. So I will just concentrate now on the key elements you need to know about this execution process. So basically, as I guess you all know, that the states, of course, they are obliged to remedy the violations which were identified by the court in the judgment. Basically, what happens when the judgment gets final? Well, it lands on the table of the CM. CM stays here for Committee of Ministers, and on the desk of a DEJ. DEJ stands for Department for the Execution of Judgments. So the member states, they have a margin of appreciation on how to implement a case, but they do so under the supervision of the Committee of Ministers, which is helped by the Secretariat. So the Committee of Ministers is this intergovernmental body, which is composed of the representatives of the 47 member states. Normally the people who are in Strasbourg in the embassies. And they rely on the technical assistance of a department for the execution of judgments, which is composed of lawyers, sometimes also seconded lawyers. So that's what happens when a judgment is final. And we'll come back to the timeline afterwards. Another concept I would like to present to you before we come back to this timeline is the difference between the individual measures and the general measures. So aside from supervising whether the state has paid a sum, so compensation to the person after a judgment has been handed down, the Committee of Ministers also deals with two types of measures and supervise the implementation of two types of measures. The individual measures, we call them IM, the one which are aimed at remedying the injured parties in order to restore the situation existing before there was a violation, as far as possible, for instance. So for instance, that the payment of compensation for pecuniary or non-pecuniary damages. It could be also an individual measure, could be also the reopening of unfair criminal proceedings, for instance, or the fact that domestic court judgments are enforced. What's important for you is are also the general measures, because these general measures are probably the one you will focus more on during your advocacy work. They target the state's obligations to prevent similar violations. That means that normally they relate to domestic reforms of law, reforms in the policy or in the praxis. For instance, a state can be asked to adopt the domestic legislation Or, for instance, another example of a general measure would be to improve the conditions of detention in prison. Very often, these general measures are not indicated in the judgment, so it's up to the state in dialogue with a committee of ministers to see what they could do. Okay, I have another participant I need to admit. Okay. Another concept what is crucial for you to understand, and George already talked about that, is the difference between the leading and repetitive cases. So basically, when a judgment becomes final, the Department for the Execution of Judgments, within 2 or 3 months' time about, will decide whether it is a leading or a repetitive case. It's a very important difference because the leading case, as George mentioned, is emblematic of structural problems or systematic problems, and these new problems call for new measures. That's why the cases are considered as leading cases, whereby similar cases will be examined in the same group as repetitive cases. But the general measures will be examined under the leading case, and this is the reason why you should focus on these cases, whereby, of course, the general measures are deemed to apply to the repetitive cases as well. You will see later on when we go to session 2 that this makes a crucial difference in your advocacy policy. The next concept I would like to talk about is the difference between an action plan and an action report. Actually, as this name said, it's quite straightforward. So after a judgment is final, the respondent state has 6 months to send an action plan. This action plan includes normally the next steps that the state envisage to implement the judgment, ideally with an indicative timetable. So the action plan really relates to the measures which might have already been taken or which are planned. It's an evolving document and it's regularly updated. We'll see later on where you can find the documents on cases which are relevant to you. And an action report basically arrives at the end of a process when the state has completed, has gone through a series of action plans which were accepted by the Committee of Ministers and the Department for Execution of Judgment. Then the action plans are turned into an action report, and normally it ends up in the closure of a case. So here you have this timeline for the overall supervision process on this graph. We'll come back to that also in session 2. I leave it on the screen. So once the action report has been adopted, the case monitoring or supervision of a case is closed by the final resolution. It means you can no longer intervene in the supervision process when a case has been closed, of course. Now we'll leave the floor to George, who will explain to you why the Committee of Ministers is an important advocacy avenue for you, before I come back to you.
Thanks so much, Agnes. I hope that's clear to everyone. There will be a chance for questions in just a minute. I'll open it up after I've said just a couple more things about the next 2 slides. So the first thing is the participatory nature of the Committee of Ministers judgment execution process. This is one of the reasons why it is so important or such a useful avenue for NGOs. Agnes, if you could just move to the next slide. Yeah. It's important to note that NGOs have not always had the ability to participate in the judgment execution process. So before 2006, it actually, it wasn't impossible, but it was a very ad hoc and difficult procedure. And for the last 14 years, they have been able to contribute to the process. And that, that opportunity needs to be used. I would like to say that the reason for that is as follows, is that you as lawyers will all have been aware of the importance of the principle of equality of arms in litigation. So you can think, for example, in your last piece of litigation that you might have had with someone, what might have happened if you weren't there to represent your client, or if the opposition's client wasn't there to represent, opposition's lawyer rather, was not there to represent their client. Important points would not have been made, important bits of evidence might not have been brought forward. And it's really exactly the same thing with execution of judgments. The Council of Europe Committee of Ministers needs to know what's going on from both points of view. And governments, for all sorts of reasons, might not provide a particularly objective version of events. And it might just be because they don't have all the information aware to them. They might not know that certain things haven't been done. Sometimes government officers in this area, they might just see their task as to get cases closed rather than really hope that submissions can change things, or hope that reforms can be made as a result of this process. And there's also, of course, some governments where it's a deliberate policy to avoid certain human rights coming in. And I'm sure we can all think of which countries might be the worst offenders when it comes to deliberate non-implementation of judgments of the European Court of Human Rights. So I'll just move to the different types of submission now. Anya has already mentioned the difference between Rule 9's and Rule 9.1 and Rule 9.2 is an important thing to mention. Rule 9 is where you can make your submissions. It's the rule that allows non-government actors to make submissions to the process. And there's two main parts of that that you can use. Rule 9.1 is for injured parties or their representatives, so that's lawyers. It's for them to submit communications about the failure to pay just satisfaction or the need to take individual measures. So that's when the lawyer, the representative of the person who was the victim of the violation, or the person themselves, the victim themselves, can write to the committee ministers and say, look, you've paid this part of compensation, but not that part. You haven't paid my compensation at all, or there still needs to be a proper investigation into this violation. For example, if a police officer has been accused of torturing someone and or committing ill treatment, they might want to say, look, there still hasn't been a proper investigation into this. Or there might be a need for a retrial or something like that. So that's 9.1, and it involves only individual measures. 9.2 submissions can be made by any non-government organization or national human rights institution, and they can submit information about the individual measures that I've already mentioned and the payment, non-payment of financial compensation, but they can also talk about the wider problems that are ongoing in the country in regard to the violations. So the failure to execute those all-important general measures that might resolve the underlying problems. So that might be legal changes to legislation that are required. It might be the need to train police officers or distribute the judgment to the judiciary and hold seminars about the importance of the European Court of Human Rights case law that's not being carried out. So really, these are the two avenues by which you can make submissions to the Committee of Ministers and make them aware of that all-important information that can change the decision-making and change the course of the supervision. So for now, perhaps what I'll do is just to conclude by saying, why is the Committee of Ministers judgment execution process an important advocacy avenue for NGOs and for lawyers? Most of it's there. I think we might want to skip straight to questions now because we are running out of time, but do revisit this slide. Governments are legally obliged to take part. The Committee of Ministers will continue this supervision until all of the issues have been dealt with. General measures can help ensure that the proper root cause of things are being dealt with, which is a huge victory for any human rights lawyer, I would say. NGOs have an unlimited right to intervene, so you can send as many submissions as you want. And finally, these submissions can make the authorities just take civil society seriously, and that's obviously of a huge benefit. But for now, I think it's best if we just open the floor up to questions. I can see one in the chat now from Grigori. I'm so sorry if I get the pronunciation of your names wrong, everyone. So what happens if the country refuses to implement the action plan? That's a really important question, and it happens an awful lot. Governments might submit a fantastic action plan to say, look, we're going to address all the problems in this way or that way, and then actually things don't happen properly. So there's important things that need to be done in reaction to that on behalf of civil society, because the Committee of Ministers or the Council of Europe won't necessarily know that there's been a failure to implement the action plan. because governments are pretty good at supplying very convincing information that things are really happening. So sometimes the Committee of Ministers of the Council of Europe will be aware that things aren't happening because of other reports by Council of Europe bodies. So there are bodies in the Council of Europe that look at prevention of torture, prison conditions, human trafficking, things like that. But a lot of the time, it's up to NGOs to inform the Committee of Ministers that things aren't really going on. When that happens, so an NGO such as the Macedonian Young Lawyers Association can submit a Rule 9 to say, look, this action plan is not happening in practice, then the Committee of Ministers, the Council of Europe, and the Secretariat of the Council of Europe can go back to the country and say, look, these things still need to happen. So what happens is the case will remain open until that action plan is actually carried out, as long as the Committee of Ministers is kept up to date about what's really going on. So that answers part of the problem, but of course there's still cases within that that have been open for many, many years, where governments, even though they're being held to account and they're avoiding getting the case closed prematurely, they're still not implementing everything. So the system isn't perfect, and there's a range of different performance of states about how well they are doing about in implementing their action plans and doing the things that they said. So I hope that answers that question from, I think it was Grigori. Might there be any other questions for the moment? I haven't seen any come in, but if there are more questions on what we've said so far, please do put them in the chat and then we'll answer them in the next stage of this process. But for now, I'll hand back to my colleague Agnes to speak a little bit more about where to start in making these submissions.
Yeah. I just put on the screen, just following the question we just had, again, this timeline for the overall supervision process. There you can see that's really, there is some time to be planned between the first action plan and then before it gets implemented. So it's really these action plans, or the whole process is a living process, right? That's why I thought it was important to show you this graph again. And just before I go, I switch to session 2 about how you can actually get involved into that process. One of the key elements I just omit, was so pressed by time to present to you, and which you can see here on the screen, the difference between enhanced procedure and standard procedure. It's actually also a very key concept to bear in mind. What does it mean? So the cases will be classified either under the standard procedure or the enhanced procedure. Under the enhanced procedure, it means that the Committee of Ministers will review the cases at its quarterly, not at all meetings, but the Committee of Ministers will really review the cases which are under enhanced procedure. It will do so at the occasion of these quarterly DH meetings, as we call them, so human rights meetings, whereby the cases which are classified under the standard procedure are dealt with more exclusively, let's say, by the Department for the Execution of Judgments. Just to explain to you a little bit the difference, the cases which are classified under the enhanced procedure are the ones which request urgent individual measures, pilot judgments, or judgments, as we mentioned before, that present major structural problems. But also interstate cases are classified under the enhanced procedure. So that was, again, some of the elements I wanted to underline here. So now we'll explain why it's important to intervene. Now, it's important to know how you could intervene into that process. So George already explained to you that the dialogue between the Committee of Ministers, the member state, but also the NGOs is a formalized dialogue. You have the possibility to take part in this dialogue through Rule 9 submissions, as we explained that. But where do you start? Where can you find the information? You could check what we call here this UDOC exec website. Maybe I can try to go online and show that to you. Hopefully it works. Yes. So this is basically the website for the Department for the Execution of Judgments of the court. So it's a little bit a similar website to the UDOC website, where you can find the final judgments, but here on this website you find the the state, let's say, of state of execution of your case. So let me come back here to the PowerPoint. You can also you will also see some specific information for NGOs on the Department for Execution of Judgments website. I put here the link. You will receive the PowerPoint presentation after the event anyway, so we can have a look. I go over that because we are pressed by time. And as I mentioned before, for the cases which are under the enhanced procedure, you will find a list of the cases which will be examined at the next meeting of the Human Rights Committee Ministers meeting online. So it's available on the website for the Department for the Execution of Judgments. It concerns, as mentioned, only the cases which are under enhanced procedure. So here again, you can see the UDOC exec website I've presented to you before. You have a lot of criteria. You can filter by country, by leading cases, repetitive cases, by dates, etc. So I invite you. It's very the place where you can find information. On the right-hand side of your screen, that's the DHA's website, where you can see the calendar for the upcoming meetings, the latest decisions which were adopted, and also below the indicative list of cases to be examined. Here it's an old screenshot, but as I said, this meeting takes place on a quarterly basis. So what you need to understand as Rule 9 submitters, so as lawyers or representatives from NGOs taking part in this formalized dialogue, is how the dialogue works, of the process. This timeline explained to you, presented to you before, but also you need to know where the dialogue has got to on a specific case. Right? We'll come back to that, but there is no point, of course, in joining a dialogue from the beginning when the other parties are already halfway through the conversation. So you will have to check out the UDOC exec website to find more details. And what's also important when you send a submission on a case is that you add value. There is no point for you in repeating information that the members of the Committee of Ministers or the Department for the Execution of Judgments are aware of. We'll come back to that in a minute. So if I come back to the database of the Department for the Execution of Judgments, if you go there, you can find the description of your case. And as you can see on the screen also, the state of execution concerning both the individual measures, but also the general measures. You can also find for the cases under enhanced supervision, some notes, which is the notes which are provided by the Department for the Execution of Judgments to the members of a Committee of Ministers ahead of their quarterly meetings. That's very important to have a look at that, as well as the latest Committee of Ministers decisions on a specific case, if a decision was already taken. And it's kind of your starting point, the place where you can find information about where we are in terms of implementation of a specific case. Now, in your Rule 9 submissions, we'll come back later on to the structure of a Rule 9 submission. It's a very important point, but as I mentioned, it's important for you also to add value, right? Adding value means that you could ask, for instance, for additional measures. What's important to keep in mind is that you need to examine the judgment closely to see whether some measures might have been mentioned in the judgment. It happens quite rarely, but it can be the case. You can also develop your own ideal list of measures and compare it with the action plan if there has already been an action plan. But a crucial element that we see sometimes is that you shouldn't go beyond what can be justified by the judgment. You can send very informative and very interesting arguments to the Department of Execution of Judgments in your submission, but if these arguments are not targeted at what can be justified by the judgment or what the judgment is calling for, then they won't be considered. They just won't be considered. Here for your information also, in order to add value in your submission to really contribute efficiently to this dialogue, some types of information you might like to convey. For instance, if you find under UDoc exec that there has been an action plan on a case you're monitoring, you should go into that and look whether you find any inaccuracy or misrepresentations, some omissions, so some information that the government is not providing, which could bring, bring to a misleading picture of to what extent the case has been implemented. You might be also interested to provide some statistics or data which could really help the members of the Committee of Ministers to assess the true implementation progress, because the point is that otherwise they really rely on the information provided by the member states. And they would need then other, let's say, arguments if they want to take a decision asking a member state to change its action plan. In that context, statistics or other data or evidence are really important. And then I put also here other elements which you might be interested in looking at. For instance, analyzing the domestic legislation, or providing more general information also about relevant developments or political or other nature, which could inform or which could lead also to problems with regard to implementation of specific cases. These types of information are also crucial for the Committee of Ministers. As we said, this Committee of Ministers is composed of people who are sitting in Strasbourg, basically, and they don't know what's going on the spot. They just rely on the information provided by the member states. Sometimes government also claim that an incident was isolated. You might disagree with that, and they provide some data to show that there were similar cases. And in order to add value, what we also underline is you should avoid to adopt kind of campaign style of approach. I think for lawyers, you might not tend to do that. That's a message we tend to, to underline for NGO representatives, but it's very important to be sober and factual in your communication. We'll come back in a minute if we have time to the actual structure of your Rule 9 submissions. Here, I just put for your information some elements where you can find new information from your own advocacy experiences, from your freedom of information requests, from parliamentary questions, letters to ministries, or over domestic reports, which are not available in English or French. And very often also we see Rule 9 submissions which refer to reports by other international organizations, which are used, let's say, to support your own arguments. Normally, the Department for Execution of Judgments should be aware about such reports, but they will come back to that. They have a very small team and they can't be aware of everything. I think I will skip that slide, otherwise we'll run out of time. Now, a last element I would like to underline with you now is the procedural proposal, which you could also think of including in your Rule 9 submissions. For instance, you can oppose the closure of a supervision process when a member state asks in an action report or considers in an action report that it has taken all individual and general measures needed and asks for the supervision to be closed. Then you can also ask in your Rule 9 submission and for the case not to be closed on the basis of evidence you provide further on in your submission. We've seen before very quickly the difference between the standard cases and cases which are monitored under the enhanced procedure. You might also ask for a specific case where you think it's important that it should be moved from the standard procedure, meaning it's monitored mostly by the Department of Execution of Judgments, to the enhanced procedure, meaning that the case should land on the desk of the Committee of Ministers during one of its quarterly meetings. That's something you can ask for. You can also ask or draw the attention of a Committee of Ministers or the JJ on delays on the side of the authorities in submitting the action plan. We said that it should be submitted at least within 6 months after the judgment is final. And you will see also, we'll have a link in our final slide. We have an EIN handbook which explains to you also other types of proposals you can include in your submissions. Now, As I said before, very quickly, the Department for Execution of Judgments has a relatively small staff. I think, if I'm not mistaken, George, it's about 40 to 50 lawyers and seconded officers. And they cover a lot of languages, but of course, we can't have an expertise in all member states' legal systems. They have a limited capacity for country visits, and in a way, they also kind of suffer, I would say, from the pressure from the member states. That's why, we'll come back to that, but it's difficult for them to verify or challenge the member state's claim, which makes it even more important for you as lawyers or representatives of NGOs to intervene into this process so that they also have, other kind of information. But because we have this limited team, you should also bear in mind some elements when you write your submissions to ease their task, let's say. First of all, and we have a specific guide about how to write Rule 9s, which you can find also online on the EIN website. But what's very important is to also follow the structure, so the heading of an action plan or an action report when you respond to it. It just makes it easy for then the deputies at the meeting to compare in a way what's in the action plan or action report and what are your claims, or where you disagree with which content, So just adopt the same structure basically in your document, and be clear about also which kind of statement or CM decision you are addressing. So really put the numbers of a CM decision, or quote the government statement, put the page numbers. It just makes it easy for people to follow, and use, of course, the same terminology and abbreviations. And a key element is keep your input short. We recommend a maximum of 5 pages for Rule 9 submissions. Again, all these pieces of advice you can find online on our website. I just show you here shortly. I want to leave some time for discussion, but again, how a submission should be structured. You find further details on our guide. So, introductory section with a brief description of a case you are talking about. No need, as mentioned before, to repeat the information which are already on the UDoc exec website, because people would know. So very small, brief description of your organization as well. And then explaining 1 or 2 sentences what you want to address exactly, if you want to answer to an action plan or an action report. And very important is also to have an executive summary of your recommendations. Basically, you recommend that the Committee of Ministers ask the member state for further data, further details about these types of measures. Put this executive summary at the start of your submission in the form of bullet points, 4 or 5 points, because the Committee of Ministers, they deal at their meetings with 25 and 40 cases per meeting, which means a lot of paper, a lot of cases, and they would then go straight away to your executive summary to have an idea of what you're talking about and what you're asking for. That would help them very much. And then, of course, you need to have a section about the evidence, what you are talking about on individual measures, general measures, and then repeat at the end of the document your recommendations to the Committee of Ministers. It's basically a repetition of your executive summary. Here the timeline again. Yes, so you can basically intervene anytime in the process. But you should also monitor on a regular basis, so EIN can support you in doing that if there are new documents on specific cases which are published online, whereby action plan or action report. But the timetable is crucial. And that would be my last point before we are talking about the impact of your involvement. I would really like to underline the importance of your timeline. Here you have some pieces of advice. Of course, it's difficult to know or to predict when a case will, for the cases under enhanced procedure, when they would be on the desk, let's say, of the Committee of Ministers for the next time, whereby sometimes in the decisions you can find information about that. But generally, here are some guidelines. So after a judgment is handed down by the court, you can already start a way to propose, to develop your own proposals for general measures. And you can look also for evidence of similar violations which are ongoing, for instance. So you don't have actually to wait. When the judgment becomes final, you can, for instance, approach the ministries domestically also to offer to contribute to the action plan and outline your ideas and asking for a meeting. So we might mention that a little bit in our concluding session, the importance also of combining the domestic advocacy with what you can do at the Strasbourg level. Following the publication of an action plan, we said, well, it's important then, if you consider that the action plan is not complete, you would like to amend, to get it amended, etc., to submit a Rule 9. But as I mentioned before, you can actually participate in this overall process, in this dialogue on an ongoing basis. So you can make submissions as and when needed to answer to action plans and action reports. For the cases which are under the enhanced supervision procedure, you can find the list of the cases which will be dealt with at the quarterly CMDH meetings. These lists are public. Just at the end of the meeting, they publish the list for the next meeting to take place 3 months later. Important, crucial, is also that if you submit a case which will be dealt with at the next CMDH meeting, these Rule 9 submission that you submit should be sent to DAJ 6 weeks before the meeting. Otherwise, your input would not be considered into the notes for the meeting. And these notes that the DAJ prepares, they are basically the basis. You know, they are sent to the Committee of Ministers, and the Committee of Ministers, the deputies, they won't read the whole judgment or all decisions. They will really rely on the information provided by DAJ. So if you want your input to be considered for the next meeting, then your Rule 9 submission should be need to be submitted at least 6 weeks before the next CMDH meeting. And then we also have some specific guidelines here for cases which are under the standard procedure. I won't go into details here because you can find a specific guide online on our website. And the last comment I would like to do now is that after you've done a Rule 9, then you shouldn't consider you're finished, of course. You need to check a little bit what was your impact to see where you're up to. And to see that, you can go to the UDOC exec database and check on the status of execution page. And in the decision of a Committee of Ministers, you can check, you know, to what extent your recommendations or concerns were reflected. So it's very important also to monitor after a CMDH meeting took place to see, well, what was the impact of my Rule 9? And watch out also, the states are obliged to, they're supposed to respond to your Rule 9, and these replies from the authorities are made public. So you should also watch out what the state is saying, is responding to your Rule 9. And you can find here also on our website more guidance on how to actually assess your impact in engaging in this supervision process on our website. So it's a study we did on 3 types of cases, which could give you also an idea on how you can assess the impact of your contribution. So that would be all from my side. George, I hope it was not too many information at once. But yeah, we're here to answer your questions.
No, I think that's great, Agnes. Thank you so much for that. And I do want to bring back Zoran in a second. I think it's worth saying perhaps that a few questions have come in, which we should try and answer. One question which we've answered in the chat is how you make a submission in the first place. I mean, in the sense that is there an application form or anything like that? It's very important to say that, in fact, you just submit it to an email address with a covering letter, and I've put the email address in the chat of where you make your submissions, and also an example that was published this week of someone making a submission that's then published, and you'll see that there's a very short covering letter there, and then the submission itself. So do go ahead and look for that detail. Of course, all that kind of information is in our handbook. I've also put a link to our handbook in the chat, and hopefully that will be disseminated as well after this event. So that kind of administrative information should all be there and very clear. We have another question from Maria, which is about a specific case, and I think I know the case that you're talking about. And I think perhaps what we'll do is we'll start talking about that case in a second, if perhaps there's no other questions about the process itself. So maybe we'll come back to your question, Maria. Well, I'm not ignoring it, but we will come back to it. There's another question here from Pandowski, which is as follows. I want to underline one specific problem regarding execution and implementation of judgments of the ECHR. Execution of judgments is a responsibility of the government, but government can't interfere in the judiciary system, which is independent. In the end, implementation of the judgments and their execution is directly related to the individual decisions of the national courts. Well, yes, that is true in some cases, not all cases. In some particular cases, it is very true. And in the example, I think the case raised by Maria, it is true that the responsibility will come down to the court. But that's not quite the end of the story, because there's lots of different things that the authorities can do, and ways in which the judiciary can engage with the Council of Europe in order to implement the judgment. So, for example, in some cases, the legislation, underlying legislation, might need to be changed by the government if the courts aren't issuing rulings that are in line with ECHR judgments. So that happens in a number of cases where we see a sort of hope on the behalf of the authorities, the executive, that this problem will be picked up on by the judiciary. They'll see the European Court of Human Rights judgment, and then they'll basically implement the case by creating new case law that's in line with the Strasbourg jurisprudence. But after many years, that might not work. The courts might not want to do that, and therefore the ball does go back to the government's court to issue or change legislation. So that's one thing. But also, you might say that governments do have a role to play in disseminating information. So ensuring, for example, that the European Court of Human Rights decisions are disseminated to different courts. Organising seminars, for example, that include international experts between the judiciary of the country. All of those kind of things can happen. But I think indeed that your question might also relate to that of Maria, and it relates perhaps to the case regarding the registration of religious institutions. So that would be the Orthodox Ohrid Archdiocese against North Macedonia group, and I know there's several different judgments in that group about different religious institutions that needs to be borne in mind. So perhaps we'll turn our attention to that group of cases, unless I just want to bring in Zoran, if I can, just to see. Great. I wonder if you've got any comments, Zoran.
Well, thank you, George, and thank you, Agnes, of course, for your presentation. It was very challenging to put all these things in a very short aspect, but I would just raise 2-3 points. I would say that our initial idea was to bring the work of EIN into our own legal community, because, of course, you are available on the internet and so on, but I believe that you deserve this kind of promotion among the attorneys communities also. And it is great that we have also the support from the Bar Association. So this was like a first step for you to get to know each other with our attorneys at law. And the second of all was to also inform the colleagues that are present here, but also, and we will share this information to the other attorneys at law, that in the upcoming period we are thinking together with European Implementation Network to become something like one-stop shop, where you can ask us and bring some issues to us. We can contact directly the colleagues from EIN, and also to establish this kind of regular communication. Because I believe that this will be something that will be also interesting in the upcoming period. So it's a one way to how we will establish these channels of communication with the Bar Association, but also directly with the attorneys. But also we will try to promote this among the NGOs, because it is also something that is interesting for us, and we want to support this kind of cases. So about the third aspect of this conference that I believe that you managed to explain it very, very simply and very clear, is the whole idea behind the implementation. Because I know from my colleagues and also on the cases that we have been working on, we put lot of effort on preparing the application and going through the case and winning the case itself. And after that, we just kind of let it go, you know, like we say, okay, now it's the job of the state to go on from here. We used to think that it is enough for us to get the judgment done. And after that, it is the relation between the state and the Council of Ministers or the court in Strasbourg. But we see now that there is another role that we need to play in order to have full implementation. So this is just one reflection.
Well, that's music to our ears, Zoran. Of course, we agree with all of that. And it's really interesting to hear you say that you would be interested in having that kind of function in Macedonia. We think that that would be really great. It's really important, we find, for one organization or a group of organizations to keep an eye on implementation in general. And that's to do a series of things. You know, first of all, it's helping disseminate information to different NGOs or lawyers about the implementation of cases. So the government might be saying, look, we solved this problem, close the case to the Committee of Ministers, and then, but there's, we can disseminate that information to you, and you can disseminate it to others. That's great. The second is to sort of help organize within civil society who's making submissions. So if you really feel like there's a case or an issue where something has to be said, a submission has to be made, but you might not want to duplicate efforts, or you might want to make sure that the right organization makes that submission that has the expertise about it, then it's great to have one-stop shop organization that can help make that happen in a country. That's really, really helpful. And third is also just to put pressure on the government as well, is to say every so often, periodically, look, you know, if you've got 14 leading cases, but a third of them, there's no action plan or action report. What's happening with those cases? You know, are they sitting there? Are things going to happen? So we hope to have more cooperation with you, Zoran. I think that'll be really fantastic, and we look forward to that. But for now, perhaps I think it's good to open it up to everyone else. Before I do so, there's one more thing I wanted to mention, which is about domestic advocacy. So a lot of the information that we've given you here today has been about engaging in the Strasbourg process. And that's because we do have a limited amount of time to go through all the different aspects of implementation. And normally we spend a whole day with people when we can do these things in person. But it's also important to remember that it's not just about making submissions to Strasbourg and to the Council of Europe. It's also important to push things forward domestically. And we do have a domestic advocacy guide that has a lot of information about how to do that, which I can put into the chat, or perhaps Agnes, I can ask you to put a link of that into the chat as well. And that's really to do, you know, we highlight the need of doing 4 different things in relation to pushing forward implementation domestically. So first, it's about having a comprehensive advocacy strategy. It's about thinking through how to push forward implementation from the very start of the litigation all the way through. Second, engaging with the authorities. It's obviously putting pressure on governments. It's about thinking about how to do that and in what circumstances it's been most effective. Third, it's, you know, having an alliance of people. If it's an issue that really requires a lot of weight from lawyers or civil society, it's great to have a group of people all speaking with one voice. That's often very effective. And 4, sometimes it's effective to communicate widely around an issue with the public. So to bring in social media communications or other media communications to help push for implementation. A lot of that's activities that NGOs will be doing anyway on different subjects. Our guide just has some information about how others have done that throughout Europe, specifically on the implementation of ECHR judgments. Okay. So, but for now, I do want to bring it back to you guys. I just see Anya's put the link in, which is fantastic. Maria, I think it's Maria or Marija. I'm so sorry if I get this name wrong. You've mentioned a problem with a certain case. Perhaps I could just ask you to come online and to just start talking about that and explain in person to everyone what the problem is and what you mean. So, if you're still there, it'd be great if you switched on your video and your microphone.
Hi.
Great, and we can't quite see you yet, Maria. If you switch on the bottom left, there should be a video.
Yes, just a second.
You don't have to come online if you don't want to, by the way.
No, it's okay.
Do go ahead.
I tried, but
we can hear you anyway. So maybe just go ahead and ask your question, and we can answer it.
Yes, I tried in short to outline how far have we how far have we get with this case, because now we had the last judgment from the primary court in Skopje. The judgment was in April, at the end of March, I think, but we received it at April, where they stated that we haven't concluded all the procedure yet because we need to file a new application, and the court will take the account the judgment from Strasbourg, but we need to apply again, which was really unthinkable for us, taking in account that if we do that, we don't have any guaranteeing that they will not refuse us again, and we will have to start everything all over. And also, we have a certain law for implementation of the judgments, but it's, by my opinion, is very vague. You cannot find any details about how the judgments should be implemented. But on the other hand, in the last judgment, the judge calls up for our civil procedure law, which also I state everything in the complaint, because I complained of this last judgment. We'll go to the appellative court. I don't know what will their final judgment be, but those provisions are really not the ones that needs to be called upon in this case, because the situation is clear. You mentioned that you know about the judgment, so they need actually to make the registration of the religious group. That is the only thing that is required. There was an issue about the name, and the state during the negotiation tried to take that provision isolated and asked from the applicant to make change of the name of the organization. But they said that if you make the change of the name of the organization, then we will have no problem for registering your organization. But that is not stated in the judgment. And in any way, can the state ask for additional things to require some conditions that were not stated in the Strasbourg judgment? I don't know if you need any more details about this.
Sure, that's great. I think that's a good introduction, I think, for everyone about this case. So for those of you who don't know, as I mentioned earlier, there's this series of cases about refusals by the authorities to register religious organizations in North Macedonia. And it's a really interesting timing for this question, because actually the committee of ministers actually issued a decision about this case, or this group of cases, today. So which my colleague Agnes will bring up here now. So there's a lot of different questions that you've raised in your intervention there, and I don't think I can answer all of them. Partly because I'm not so familiar with the domestic court procedure in North Macedonia, and it's certainly something that we can talk about more. So please come back to me and let's maintain a dialogue about this, because I think it will require more discussion. But what I want to talk about now is really how the committee ministers is currently dealing with it and what you can do about it, to my best knowledge. So you said earlier on that there's this litigation going on in North Macedonia at the moment. Earlier this year, and there was a court decision about one of your cases. Can I just quickly ask you, Maria, which case it is? Is it the Orthodox Ohrid Archdiocese, or is it the Bektashi case?
It's the Orthodox Ohrid.
Okay, great. So it's the headline case in this group. So what you'll see here is that the Committee of Ministers has actually dealt with this group today, and it's issued a decision about this group today. And what this decision is a result of is submissions from the North Macedonian government. The North Macedonian government submitted an action plan in March about what they say has happened in the case and what their view of what's going on is, right? But there's no submissions in that period recently from civil society. So this is a case where there's basically the Council of Europe is only getting the view, at least this year, right? There was some information last year, but this year, subsequent to the litigation judgment that you referred to in March, the only information has come from the government. So what you'll see there in regards to your case is paragraph 4. Basically, it notes that the litigation is ongoing, and essentially what the Committee of Ministers says is that they note that the applicants didn't provide the documents requested by the court or follow up on the court's efforts to find a solution, and that these decisions may now be challenged before the appellate court. So I'm sure that you would have a different view of what they should be concluding about that. But that's the submission that's been made from the government, and it hasn't been challenged by anyone. So that's what the Committee of Ministers has decided. But it does note that the case is now pending before the appellate court, which is very interesting. And essentially what's happening here is the Committee of Ministers is saying the government has supplied information about this case. It's ongoing. The government's saying that the applicants aren't helping the case get implemented from their own actions. So we're going to wait and see what happens. So they're waiting for more information, essentially. So this case at the moment, it's not clear when it will come in front of the Committee of Ministers again, but essentially what they're waiting for is more information about implementation, because the government's saying that this, the government's basically saying it's down to the applicants themselves to implement this case through domestic court activities. So in that situation, I think what you have to do is, unfortunately, you have to pursue the domestic litigation in this appellate decision. And then, unfortunately, what you'll have to do, if that's not successful at the appellate level now, you'll have to restart the registration process. And only then, if it's denied again, you can come to the Committee of Ministers and say, look, the government isn't implementing this case, the court isn't implementing the case. And then you can have this argument about whether you have to change the name or not, basically. Does that make sense? So in summary, the government's saying the applicants aren't doing the right thing at the domestic level, therefore we have to wait for them to do these things. And the Committee of Ministers is at the moment agreeing with that because that's all the information they're getting. Okay. I hope that's relatively clear, but do come back to me now, Maria.
Yes. Okay, thank you for the information. And I will check this and read it in detail, which you just showed us. And I will see what we can do. But it's the whole situation. It's a bit frustrating, especially when you have the time that has passed because sometimes when we speak with our clients and with the applicants, it will be a very difficult situation if I present to them and tell them that maybe we will have to go through everything again, because in this situation we have an applicant that is discriminated in many ways. It will be a very difficult situation, but I, of course, as far as I'm doing, but I will continue to do as well, and see what possibility will I get from our domestic laws. And I don't know what will the outcome be. By my opinion, I don't know what is your impression, but it is a bit complicated. It is like the state it's putting a lot of resistance, and I cannot explain why.
Yeah, were you referring to the complex nature of the system is also very challenging. I mean, it is quite a difficult thing to get to grips with, I think.
Yes,
all the material that we're covering, so it's not designed to be really transparent, in my opinion. So, you know, it's not easy to engage with. But I hope do stay in touch with me. I mean, I'll send you a message now with my contact details, and then we can liaise further about this and see if we can resolve it. Or perhaps Agnes, you could send her a message privately while I answer these questions with your contact details, or so we can continue this conversation.
Yeah, and
about
I just
that
also
case.
sent you the link also to the Committee of Ministers' decisions taken today, so you can have a look also.
Okay, thank you very much.
You're welcome.
Great. Okay. So that's in regard to that particular case. But are there questions about or people contributions that people want to make about anything we've talked about, or any other cases, implementation in general? It would be great to hear anyone else come in. For now, maybe Zoran, I see you've turned your video on again. Maybe you want to say something else?
No. I just
be fine.
Yeah.
Okay, great. Well, no worries. We'll leave it open to other people then. Perhaps there's someone else who wants a question, or to ask a question or a clarification on some of the information that we put forward. So you can either put your question in the chat box, or just basically turn on your video and your audio and go ahead and ask us a question. That's absolutely fine.
And I also put here on the screen, again, our contact details, so the website where you can check out the information. I also sent you through the chat, the direct links to the guide about, how you can get engaged into the implementation process. We also have a small, very concise guide about how to write concretely Rule 9s following the guidelines I've tried to explain to you very quickly today. And then the very recent toolkit we have about domestic advocacy and the importance of combining this Strasbourg-based advocacy with the domestic one, as we've just seen in the case we're talking about before. And you can also find here our contact details, the email.
Great, that's perfect, Agnes. Thanks for putting that there. I'm conscious that there's no more questions coming in that I can see. And I'm conscious also that I hear the rules have changed for North Macedonia in regard to your lockdown, and I'm very sorry to hear that the virus situation there has got more serious. So I don't want to take up more of your time if there's no more questions coming in. So I think for that reason, for now, Zoran, unless you have any objections, maybe we'll tie this session up.
Yeah, thank you, George, for being conscious about the situation. Actually, I wanted also to wish good health to everyone, and thank you very much for joining. I believe we have only a few hours left to do some shopping for the weekend of groceries and all other things. So that will be from our side. We are so happy to have this big number of colleagues that attended this webinar. Grigoria had also one question before, saying this is not enough, we must take more detailed training about this. So I would just leave it open as a final remark to discuss more on how to engage, and also to encourage all of the colleagues to come up any kind of topics that are specific topics about implementation. Maybe we can prepare more the material on this, share with you, and that kind of things. So just as a final remark, I leave this communication open and not closed, so we can discuss how to develop in future.
Sounds great to us, Sultan.
Thank you very much.
Zoran, sorry. That sounds perfect. Okay, I think that's all from us. Thank you all so much for attending. Your participation is great. There will, I think, the Macedonian Young Lawyers Association will send out something to everyone to see your input about what we've done, and it would be great to hear from you about what you think of this process or what you think of our training. We're always hoping to improve, so do contribute to that if you have things to say. Angela, I see you coming in.
Yes, I just wanted to inform you that I will send evaluation and then there everyone can say what's on their mind if they want another training. And also all the materials that were sent in the group chat, we will share with all the participants. So if anyone has any ideas of another training regarding the implementation of the Strasbourg Court, they can write to us, we can contact you, and we can continue to have this kind of activities and other activities regarding this topic.
Great, thank you so much, Angela. And you and Zoran and everyone at the Macedonian Young Lawyers Association have been great. So thank you so much for this. And I hope our interaction continues.
Thank you.
But for now, goodbye, everyone. I hope you can get to the shops.
Yes, goodbye.
Bye-bye.
Bye.
Bye.